I'm a master of McLaughlin College. I want to begin first by thanking the university and QP 3903 for reaching an agreement in time for us to hold this session today. One of the traditions here at McLaughlin College, in collaboration with the School of Public Policy Administration, is to celebrate about half a dozen United Nations recognized international days throughout our academic year. One of those is Refugee Rights Day in Canada, which if you don't celebrate on or as close as possible to Refugee Rights Day is kind of not the celebration of the day anymore. So we needed the strike to end in time for today's program to occur. Second, I see almost everyone has been up signing in. Let me just remind you, students in the room, that McLaughlin College gives a certificate of participation to students who attend 6 or more of these lunch talks throughout the year. And the way we know if you've attended 6 or more of the lunch talks is if you've signed in on the occasions when you are here. So if you haven't signed in already, you can wait until the end of the session, but please do before you leave. Also, at the back of the room, there are copies of a handout relevant to today's session. We'll pass them around, but please make sure you each have one of those. Now, this is, as I let the cat out of the bag already, the celebration of Refugee Rights Day in Canada. Our speaker is the former coordinator of the Interchurch Committee for Refugees, and let me congratulate you and the Interchurch Committee on Refugees for the really terrific work that has been done over a number of years. And you will talk about how today's circumstances compare to some of the rest of that work. Tom Clark is also the founding coordinator of the Center of Refugee Studies Summer School here at York University. And we could not have found a better person to speak to today's topic. So I will stop talking, and you can hear the person that you all actually came to hear, Tom Clark.
Well, thank you very much. I asked for a microphone because my voice is normally soft unless I try hard. So you're going to get my parade ground voice. That's what it is to me, and hopefully you'll hear. And if you don't, because I relax and it falls off, please wave or something, because if you can't hear me, you won't at least be able to criticize. Refugee Rights Day, April 4th, 2015. This was a day that was created by and for the refugee serving agencies in Canada. I don't know, I mean, I was part of that at the time. I don't know how we did it, but there was nothing. The Supreme Court decision that's under the name Singh, or a group of people involved, came out on the 4th of April. It was a good decision. This is the 30th anniversary. And I guess the agencies decided to make it a kind of memorial of that impressive event. And it stuck. And there's a Refugee Rights Week following this when different agencies are holding events and all sorts of things. Now, I'm going to take you back a bit because since I've been around a while, I have some history. This case, the Singh decision that gave us a breakthrough in the beginning of refugee rights, I think, in Canada, it came 2 years after the 1982 Charter of Rights and Freedoms brought in by the Trudeau government with the repatriation of the Constitution. So there was a court that was almost looking around for cases that could establish precedents. This was the opening years, and you'll find lots of interesting and impressive decisions by our court in that period. At the time, there was nothing. There wasn't a United Nations Day around refugees. That has happened since, and it occurs in June. And it was created largely around promoting the High Commissioner for Refugees and a bit of fundraising. So that is yet to come. And the Canadian Council for Refugees does celebrate that, but this is by far the biggest celebration. And it's a good time every year to take stock about rights of non-citizens, as we call them, the people who are not citizens. They used to be called aliens, and some of us successfully managed to get the international system to adjust the name to non-citizens, which is so much nicer. So let me see if I can take you back to that decision and what made it so useful. At the time, 1984, an immigration official interviewed people who said they were refugees, and they wrote it out, and they sent a report to Ottawa, where a committee sat periodically, and that committee advised the Minister of, I think it was Employment and Immigration at the time, and then the Minister made his decision and announced his decision. And the Minister would send that to a kind of court-like body, a tribunal, the Immigration Appeal Board, and if you were lucky, the appeal board would say, yeah, you have some problems and we'll hear you, or they would say not. And it involved information that the applicant never saw. Now, the person who said they were a refugee could, of course, send information in, but it was in a vacuum, because all they saw was the minister's cursory notes about why the minister decided you were not a refugee. And the person also had to prove that the minister got it wrong. So you're trying to take on a minister, you don't know what the minister was basing the decision on, and although you could send information, it was not very good. Now, having said all that, it won't surprise you that in the Supreme Court decision on this case, Judge Wilson said that she found that this not knowing what was said about you, what the case was against you being a refugee, she found that impossible to reconcile with what are called fundamental justice, what's called fundamental justice. So that's really what the Singh decision hung around, giving a person who said they were a refugee a fair crack at the can, a fair hearing in Canada. I can perhaps tell you why I'm a little bit familiar with this old case, because in a little room down at Jones and Dundas, I was called to a meeting. I'd been on the job with the Interchurch Committee for Refugees for probably a little under a year. And there were some sharp young lawyers there. And of course there was some of the church people of the day. And as we sat around on the sofas and stuff in the little Jones Avenue apartment, it transpired that the reason I was there was that it seemed the Supreme Court wanted some opinions, some interventions as they're called, by outside bodies, and the lawyers thought that the Canadian Council of Churches would make a good intervener. So that's why I was there. So I was the staff person that had to get the Canadian Council of Churches to agree. and they did. And since church people, as James knows, people like me, like asking questions, and the fact that somebody is a lawyer doesn't intimidate me. So we raised some questions, and together we kind of shaped what we thought was important for the court to hear. And we argued before the court that the 1951 convention connected refugee status determination, a process that's occurring in Canada under the jurisdiction of the Canadian courts, with a situation that was elsewhere and outside the normal jurisdiction of the Canadian courts. And our view on that happily prevailed. So let me tell you the interesting things and how the rights for refugees comes in. The right not to be removed to a country where life or freedom may be threatened, which is the basis of refugee protection, was deemed to be at issue in this court decision. And the denial of that right amounted to a deprivation of security of the person, which is one of our fundamental rights in our Charter of Rights and Freedoms, and that required a hearing that conformed with fundamental principles of justice. So that's what we got out of it. Now, how many of you think that this decision was based on the Canadian Charter of Rights and Freedoms? And just a show of hands, straw vote. Yeah, well, those people are half right. How many people think that it hinged on another piece of Canadian law? Yeah, James knows. Yeah, well, these people are half right too. And that's not generally known in a legal community at this point. But half the judges that were involved in this decision, 3, based their decision on the Bill of Rights, which was an instrument that had been introduced, for those of you that are great on history, by the Diefenbaker Conservative government. This was a time that will seem shocking to you, but Conservatives were progressive at one time in Canadian history. And some like to think that they still are. So, yeah, interesting, isn't it? Who would have thought? And that law, under the Singh decision, the case that we're looking at that established the refugee rights, that law was kind of reinforced in the decision. It was given what should have been a new burst of life, which never happened. But that says that no law of Canada, including the Immigration Act, it's a federal jurisdiction law, shall be construed so as to deprive the person of a fair hearing in accordance with the principles of fundamental justice for the determination of his or her rights and obligations. So that was 3 of the judges. And the other 3 judges, including Justice Wilson, whom I happen to like, because she said some wonderful things in this decision. Everyone has the right to life, liberty, and security of the person, and not to be deprived thereof, except in accordance with the principles of fundamental justice. That's the Charter, Section 7. And it was progressive at the time. Now, some of us who are not lawyers take it as self-evident that everyone means everyone. But when you start talking to immigration department lawyers, you can run into troubles with that, not just here. But our court gave a ruling that said that the everyone in that Charter Section 7 meant everyone, essentially. Every human being who is physically present in Canada and amenable to Canadian law. So there you have it. And yet in the mid-1990s, you know, more than 10 years after this, you had people in airports in France, and France was arguing that they're not really here. See, because immigration officials think that you're only really here when they say you are. I mean, the fact that you are doesn't matter to anyone. It still tends to work that way. So this was very important. And so it was cause for celebration. But I should say that on the day, and I didn't bring it, but I have a copy because it etched itself in my memory. I have a copy of the Globe and Mail of that day, April the 4th, just the Xerox of the relevant section. An article reporting the then minister, who was Flora MacDonald, and a progressive woman. She said she'd ordered her officials to comply with the decision, I'm quoting, and find new procedures for weeding out those who falsely say they are refugees. And that's all we've seen since. This decision paved the way to the Conservative government of the day introducing what is now the Immigration and Refugee Board, on which James served, and successive governments have tried to find new ways to weed out groups of refugees that they didn't think were worthy. The last change to the law was concerning Roma refugees from Europe, you may recall, in that regard, but there are others. Now, have there been any other good signals since then? I thought to myself as I was coming here. Well, maybe, but only very partial. And if you've got any patience left, you'll need to learn about a wonderful device in Canadian immigration called the Security Certificate, which James can help me out on if I get it wrong. The ministers can issue a certificate that says that a non-citizen can't be in Canada. This is the immigration people saying they can't be in Canada. The fact that they are, you remember, is hard for immigration officials. But still, we still have that Supreme Court thing. And that's usually done these days on grounds of national security. And the reason why that's relevant is because the current preoccupation with terrorism, etc., is morphing and merging into that older concept of national security. This was there for the spies from the Cold War, Eastern Europe, and all the rest of it. That's the backdrop. Anyway, the ministers can issue this certificate, and this certificate gets reviewed by a judge. And the question is, for us, is that, and this is the notion of Refugee Rights Day to me, is that a fair process? Is it a fair crack? Is it a fair hearing? And that's what came up in this case in 2007 called Sharkawi. I don't know whether I even pronounce it correctly. And you'll forget, but that's fine. You can always ask me and I'll send it. Well, if you have one of these certificates issued against you, you face indefinite detention in practice. And at the time, you could be detained for 6 months. And the feature of this process was that the process could hide from you some or all of the information that gave rise to that certificate. Now, the certificate does two things. You can be detained, you can be jailed for these indefinite periods, and you can be deported. Because since the immigration officials say you're not really here, you haven't been found admissible, you automatically face deportation. So that said, this case didn't look at the deportation, sad to say, but the Supreme Court likes to hedge its bets, and we have to find another case to tackle that, right? Well, the good news about this, the Supreme Court in this decision, I said it was good news, said that it required a fair trial, the review of this detention and the review of the certificate before an independent and impartial magistrate, and they put in writing the right to know the case against you and the right to answer that case. And they said unfortunately in my view, that the certificate is okay. They didn't throw it out. It gave the government a year to find ways to give the person more access to the case against her. And they said long periods of imprisonment pending a deportation do not violate rights to liberty and no cruel treatment, so long as there's a review of all the factors, and so long as the judge who's reviewing the evidence for reasonableness conducts a searching, that's the word in the law, searching review. They also said, this is a bit shocking to me, that non-citizens don't need to get the same treatment as citizens, because our Charter of Rights, Section 6, which is freedom of movement, your right to come into Canada and to leave it as a citizen, doesn't apply to non-citizens. That's a little problematic for me, because our international rights, treaty signing, doesn't quite accord with our charter on that matter. So, from a wider perspective, our court is incorrect on that. As a matter of fact, in my view, and I'm not a lawyer. The court noted that there were ways of balancing hiding one's sources. Sources of why you're a spy and so on, get you into secrecy and all that stuff that we're now facing. And so protecting sources has become an issue. But they said the UK, United Kingdom, has a process with what they call special advocates, and so you can do better than you do. So, do we celebrate that one, or do we say, I don't know, it's a toss-up. Depends how progressive you are. The United Nations Committee Against Torture reported on us in 2012, and they didn't think it was adequate. They thought the special advocates were not adequate. And the material that I've read tends to indicate that too. If you want my view on this, it's much better to use the old established criminal justice system. But the trouble with that from the government's point of view is that you couldn't prosecute enough people. I mean, they don't have the evidence to do a good job. Now, if that happens to a criminal in Canada, what happens? We don't have enough evidence and stuff.
The case gets thrown out.
Yeah, they're still roaming the streets among us, and that hasn't hit the fan. It doesn't hit the fan in most places. But for some reason, when you get into this immigration stuff, our government has not gone the route of using the criminal justice approach, for which there are well-established patterns for doing that. So you see in this Shakui decision, you got this mixed blessing. Yes, they're under the Charter of Rights and Freedoms, and yes, they should hear the evidence, but they're not the same as citizens, and the British system's fine. Now, before I wrap up, I should tell you that in 2014, near the end, this issue of those security certificates in detention came back, and a case involving CSIS, our security intelligence, a case called Harkat, who had been one of the cases listed under the grouping Shakui back in 2007. But this is a fascinating case, because essentially the court muddled around and came out saying that if the judge that was reviewing the certificate was very careful and chose what evidence should be released and what shouldn't, and so on, it could be made fair. This was As a layman, I don't like it at all. I think it's fudging. And it's particularly surprising that Harcourt, by the way, won in the sense that he went back for a rehearing of whether his certificate was reasonable or not. So in that sense, he won. But if you read about what went on in the case, CSIS, the court found that CSIS had wrongly destroyed its evidence. So you couldn't call it fault in that case. But nothing like a mistrial or, you know, there was no sanction, nothing. All CSIS kept was summaries. And the court went to some length to say that, but your legislation doesn't allow you to do that. So they were illegal. Anyway, it didn't help Harcourt. So that's, as far as we've got in the Supreme Court, that's the very edge. Now we have Bill C-51. And as you probably know, if you watch the Canadian Council for Refugees on the listserv, as at least a couple of people here do, the Canadian Council for Refugees opposed some of the changes because they would allow more immigration decision-making to be open to the minister not making the evidence, all the evidence available. So other kinds of hearing, general detention review, or appeals before the Immigration Appeal Division, the minister can now ask for the evidence not to be disclosed, and that wasn't possible before. So, a bit of stock taking. Singh is certainly worth remembering, but even in this narrow little area, the struggle with lawyers and courts and interveners, now the Canadian Council for Refugees, Amnesty, sometimes the High Commission for Refugees, that's chugging along, largely hidden from public view, but very important for rights and freedoms of non-citizens in Canada. And there are a lot of other issues that the Canadian Council for Refugees has that are on your sheet. But that's all I plan to share with you today. And if you have any questions and stuff, I try and answer them.
I'll leave it to you to recognize questions directly.
Hello.
Sorry, I just have a question. What is the best way then to secure yourself as a refugee to Canada? Because, like, if you're coming from a different country and you've had this sudden idea, well, maybe I want to have a better life in Canada, how would one go about those routes into ensuring that they become as Canadian citizens?
Well, yeah. I guess if you had come into my office, I would have said, get yourself a good lawyer. And if you're really a refugee, you'll likely make it through our system. The trouble is, if you don't get a good lawyer, or something goes off track, or you run across some immigration official and they dig their heels in on some of these provisions that can declare you excluded or detained, you can have a hard time. Yeah. Yes, everything that's chopping back on rights for refugees still has a kind of line in it. It's kind of creeping. So that, for example, the Roma don't get the automatic appeal and stuff like that. And they have a rushed process to make it harder. But they still have a process. You know what I mean? So, that's my answer. Yeah. I get a tough question from you.
No, I just thought, actually, when you mentioned about people in airports in Paris, actually it made me think of another way of denying people the right to make a claim in Canada is actually preventing people from getting here. That there was the recent Harvard University study that talked about, I even quoted, I think, CDSA, and it had a diagrams of the ways in which they push the border out, which includes, well, you know, finding people, or finding finding airlines if people come, that they're not happy made it to Canada, or putting border people in foreign airports. So it's just another way of depriving people from that way, and if everyone on Canadian soil has these rights, is to keep them from even arriving here. So more, maybe more comment, although if you have any comments to make on it, I'm curious.
Yeah, I'm cynical. The big thing, and the big bottom line, right, in the refugee world is not to be immediately sent back if you are if you manage to arrive in a country. So that's the non-refoulement, and we then have to see if they are a refugee, and but the default is that they're allowed to remain somewhere, and they get to some country, and then, as you say, Canada makes it difficult for them to get here. In a way, though, it's already difficult for them to get here. I mean, we almost don't need it. There's a finite number of airlines and flights and so on. We found that out when there was the uprising in El Salvador. I mean, you couldn't move people if you wanted to. There just aren't enough air flights. And the land border you have problems with. The reason why that problem of yours exists is that when the governments were writing the treaties to protect refugees, they couldn't get beyond saying, if somehow you're in our territory, we will. That's how it's set out. So, you know, they naturally now are exploiting it. I mean, if you can't get to territory, their obligation to some extent ceases, although if they're actively dealing with you, other things kick in. I think what's going to happen, and if I sound a little incoherent, it's because I'm thinking while I stand here, and that's not good. But I think the human rights treaties are moving more on that one. Because the human rights treaty thinking and their case law, we've signed onto some of those, says that if you take somebody under your jurisdiction, then you have obligations to do those things that you signed on to. And that includes things like not allowing the person to be sent back and so on. So some of that kicks in if you have an official actually taking charge. Of course, they don't quite do that, do they? They put fines on the airline, so they compel the airlines to do that, so that it's not quite the government official doing it and so on. So anyway, you see, yeah, there is a game. On the other hand, if Canada isn't pulling some weight in this area, then it gets hard to say to other countries. Right now, one thinks of Turkey and Syrian refugees, and Jordan and Syrian refugees, who were, you know, swamped with people who can walk across the border, and like our officials would prefer to say, no thank you, if we're not playing the game. So Canada does play the game, so it can say, you too need to look after refugees that come onto your territory, right? So my sense is that we will always let some come, whatever the respectable number is deemed to be. But we try and scare them away with a lot of tactics and moderate the flow. That's a long answer. Sorry about it. Somebody else needs a chance.
I just had a question about the immigration process. Like in order to be accepted into a refugee, they usually have their story. So is there a degree of measure of their stories and what situations they're in? And I even heard that if you go against your own country's government, that the likelihood of you getting accepted somewhere else is like really hard when you, even though you go against your own government for a good reason. Like, is
James, can you answer that better than I? You were on the refugee board.
Yes. When you have your hearing, your claim is going to be assessed on the basis of credibility. So one of the things that you'll have to demonstrate is that you are the person you claim to be, and that your experiences actually took place. So that's a credibility assessment. The first one is the identity. If you can't establish your identity, then you can't establish a basis for a well-founded fear of persecution against your country of nationality or the country of former habitual residence if you're a stateless person. So that's part of the process. I'm not sure about the second part of your question, which was, I think, the person left and went somewhere else, and they've made this claim. All of the hearings are supposed to be in camera. That is to say, they're private hearings, unless there's an application that's made to the board that it become a public hearing, because it's in the public interest to do that. And those kinds of applications are only made in high-profile cases where the media has a real interest, and they'd like to have that opened up and report on it on a regular basis. So the process is supposed to be held in secret in camera, because clearly if the state that you're claiming against, depending on the nature of that state, finds out you're making a claim, then that could actually make out your case. Because if they feel that you're making all these allegations against them, et cetera, should you return, then you could be incarcerated and tortured, et cetera. So that's one of the reasons why these hearings are in camera. Or, obviously, your family could be impacted. Even if you were accepted as a refugee, the mere fact that the state knows that you're in Canada now, you made a claim, you may, in fact, go after immediate family members. So, yeah, it's very important that that information not be disclosed. Now, what's happened in the past is that once the case goes to the federal court proceedings are public. So at that point, if people are following the court cases, the federal court of appeal, or the Supreme Court of Canada, you could identify in the past, at least you could identify who these people are. Now I've been noticing that they've been using initials for the cases as opposed to actually using the person's names. So they may be changing that process. That's routinely done in other states. It's not, it hasn't been the situation in Canada. But because our court proceedings are public, anyone can attend those. And you could see the appellants, and you could hear their names, presumably. So those processes can't be held in camera, but yes, it can create all sorts of problems. And I guess one personal example was the board undertook an investigation because we have there's a research office which is recognized internationally as being an excellent feature in terms of our decision-making process. And they actually conduct investigations, and they can contact embassies, Canadian embassies abroad, high commissions abroad, or they can actually retain counsel in these other countries to undertake some sort of investigations in terms of the claim itself. Unfortunately, in one instance, they notified the authorities, either inadvertently or directly, because they wanted to confirm the identity of a particular person. As soon as that happened, that made out the person's claim for refugee status. So these kinds of administrative errors, where they're actually trying to verify the identity of a person, if If it comes to the attention of the foreign state, that could immediately make a claim. And in this instance, it did. So, does it impact, if you're rejected in Canada, does it impact you if you go and make a claim somewhere else? If that's the second part of your question, it can. Because if you say you spent 5 years in Canada, you went through the refugee process, and then and you were rejected in Canada, and you went to some other country and you made a claim there and you started the process again, and that government then contacts Canada to see whether or not you actually had filed a claim in Canada, and what the outcome of the claim was, that could be disclosed as well. And then that becomes evidence in the case that you have, the refugee case that you have in that other country. And we routinely received information in some instances where people spent long periods of time in Germany, as an example, or France, and started a refugee process there and were rejected. And then you look at credibility again, you look at the basis of the claim, the basis of the claim said, I was in this country over the last 5 years, but in fact you were in Germany making a claim for refugee protection, then that undermines the credibility of the case, right? Because there's a glaring inconsistency. That might not obviously lead to a rejection of your case, because you still could have a well-founded fear of persecution on return, even if you were in Germany for 5 years. But it just points out that obviously, there's a problem in terms of your evidence with respect to your claim. There have been other examples of this as well, where people come and claim in Canada, and actually, they went to Sweden, they were recognized as refugees, they got citizenship in Sweden, but then they come to Canada and claim. And if you have protection in another country, if you have status in another country, you can't come to Canada and claim refugee protection because you've already got protection in another country. So that happens, and you kind of wonder, why would someone come to Canada and claim refugee protection if they're already a citizen of Sweden? Sweden seems to be a very nice place, and the climate's almost similar to Canada and so on. So you do have those kinds of situations that occur, but if you're in Canada and you're rejected in Canada and you go to another country and you claim in the other country, we've had situations where we've accepted refugee claimants that weren't accepted in other countries. And that's probably the case as well for people that are rejected in Canada. They go to another country and they can be accepted there. So it doesn't necessarily mean that you can't go elsewhere and claim and be accepted.
Okay. Yes.
I wonder how you or possibly Professor Simeon can comment on, there was a Libyan family that they were deported from here. They had claimed that they were opposition to the government. They were deported, they were tortured. They have to flee again. They went to another country, and Canada has accepted them back now. So these years of torture, who is going to be blamed for? What is the way to approach it, to prevent it? And that's not the only case, because another young person of Somalian origin who did not even know anything about Somalia, he was taken from here to Kenya and smuggled from Kenya to Somalia. And he was tortured. He says, I don't speak Somalian. I don't know anything about Somalia. There is nothing in me about Somalia except for blood. So I don't know how we can define this, how we can prevent this, actually.
Well, yeah, I mean, I don't know the detail of those cases, but I'm aware that there are cases of people who are sent back and get tortured. And I'm aware too that there are cases that the United Nations Committee Against Torture has recommended Canada not send back, that are sent back, and they're not tortured, and the Committee Against Torture says that's fine because what you're supposed to decide is to protect the person from the threat of torture. It doesn't have to be sort of like the death penalty, sort of guaranteed. In fact, there's a little remark to Canada in one of the decisions along those lines, like maybe you've forgotten what you're measuring. So that happens. I mean, I don't know, it's years since I reacted to that, and at the time I said to the lawyers they should sue for damages, because that's the language that the government would understand. And I guess if I were the government, I would try to say to the person, if we let you back in, will you let us off the hook for damages? I don't know whether that goes on, but sometimes if you try and sit in their shoes, you can figure out what might go on. But I mean, yeah, I mean, there's a very early case. Somebody, I think it was some airline official from Morocco or something. Amr Khami, do you remember that one? Way back before the European Court of Human Rights, and his wife sued for damages because they didn't give him asylum. British didn't give him asylum in Gibraltar, and he was sent back and killed, as one might have guessed, because there was a regime change. And that court gave her damages. So that there's a benchmark along those lines, and it has always seemed to me that that's the way our justice system normally deals with things, where somebody's negligence or whatever causes serious damages, and so that's the avenue. You'd probably end up having our Supreme Court doing a kind of talk itself out of the problem, pretending it's a House of Lords and being political and stuff, as it does.
Nila Hayek is a reporter of CBC. Nila Hayek is
Yeah.
a lady who is a
Yes.
reporter for CBC.
Yeah.
Her parents were similarly faced this. Fortunately for her, she improved her English when she was back home, and then she made it back because she was born here, and now she is relatively a great person, but this rarely happens. The suffering of those years can never be compensated. I don't think they can ever be compensated. But therefore, there must be a way to prevent it. This is why I'm raising the question. I'm not asking for anything, I'm just...
No, I'm hearing you, but I mean, I think the mechanism is supposed to prevent it, but it fails. And it's human, and it can be made better.
There's two things to keep in mind. Regardless of the outcome of your claim, it doesn't necessarily mean that you would be removed from Canada, because there are some countries that can establish your nationality, you'll never be returned. There are other situations as well. Tom alluded to exclusion. You can be excluded from, first of all, there's the inclusionary portion, as you know, then the exclusionary portion. So if you're determined to have a well-founded fear of persecution, and hence State Convention refugee, you can still be excluded. And one of the reasons for exclusion under Article 1A is if you're a war criminal, or you've committed crimes against humanity. Therefore, that means even though you're a refugee, you would have a well-founded fear of persecution. Should you return to that country? As an example, you were head of a military group, and that regime was overthrown, and now there's a new regime. If you were to go back, you were identified as part of the old regime that inflicted torture on all sorts of citizens and so on. So you would probably face the death penalty, no torture, et cetera, et cetera. So one of the things that's supposed to apply, although it doesn't necessarily apply in practice in all situations, is you can't return anyone back to it's just cogence. It's established principle in international refugee law, regardless of whether or not a state is party to the 51 Convention, 67 Protocol, or other refugee rights instruments. So you can't send anyone back for persecution or torture. So that's one of the things to keep in mind in terms of this. So even if you're a war criminal or committed very serious, heinous crimes, international crimes, you will not be sent back to be tortured or to be persecuted.
In theory.
In theory. I'm not saying necessarily operates in practice, but in theory. And then what is emerging in the world today is the problem. And one of the problems is politically, these individuals, high-profile individuals that are known to have committed very heinous crimes. Mugesera is an example of an individual who was part of the Rwandan genocide. They actually filmed this person giving a speech calling upon people to kill as part of the genocide. And he was identified by his own community here in Montreal. He arrived in Canada. And that's how he came to the attention of the Victorians. And that started a whole process of removal, and eventually he was returned back to Rwanda, where he's going to be prosecuted. But there's a whole different process in terms of undertaking that. So the problem that's emerging is many of these individuals are in a state of limbo. They are not recognized as refugees, but because of their serious criminality and their fear of being persecuted or tortured on return, can't be removed. So this is the label that's been used, shorthand in terms of describing this situation. They're undesirable individuals because no one wants to take in individuals who are war criminals or people who have committed crimes against humanity. No state in the world would want to do that, right? Yet on the other hand, they can't go back to their own country, so they're not recognized in any way. They're in a state of limbo. So how do you deal with these individuals, this growing number of individuals? And why do I say growing number? Just look at the world today. Look at the state of the world in terms of armed conflict and war. And Syria is the prime example. What is it, 3.5 million people that have been displaced in Syria since that war started. And it's a crisis in the Middle East. But that's only one country. We have Sudan. We have the Democratic Republic of Congo. We have Myanmar. We can go down the list. Pakistan, India, Yemen. There's all sorts of countries in the world. There are 25 recognized major wars that are taking place in the world today. What is the principal cause of refugees in the world? War, armed conflict. And that is escalating. It's not decreasing. Just look at the statistics that are coming out from the United Nations High Commissioner for Refugees. Phenomenal numbers of people are being forcibly displaced as a consequence of armed conflict around the world. That is a serious problem. We cannot contain armed conflict. It's escalating. Look at Russia and Ukraine. The refugee problem is not diminishing. It's increasing. And if the main cause is armed conflict, inevitably, you're going to have people that are escaping these situations who are involved in the armed conflict, who are probably the perpetrators creating the refugees, who want to have asylum. So the issue of exclusion is not going to diminish. I would argue it's probably going to increase over time. And that's not to say that many of these individuals never come to the fore, because if you're a war criminal, you'll never tell anybody you're a war criminal. It's your own community members who suffer under your hand who will probably identify, as in the case of Mugesera. So many of these people slip in very easily. And it's in fact very offensive then when you're a member of the community, you're part of the diaspora, and you see somebody who is actually responsible for maiming, killing, torturing people amongst you. And you get very offended. And it's actually actually members of the own community that report individuals like this. And that's how Canada finds out about it. So that's one point in terms of all of this, and I'm sorry, but I sort of this sort of takes me over in terms of the situation internationally and so on. But the other part, going back to your question, is there is a method by which individuals, even when they're rejected, can apply not to be returned. And that's called the PRAW, and that's the Pre-Removal Risk Assessment. So you can apply for a PRAW, and then your case will be reviewed. And if the risk is high that you're going to face persecution on return, then you will not be sent back. And I can tell you there's an informal process as well. Even if your PRA is rejected, and there are very few people, incidentally, that actually get a positive decision on a PRA. And that's one of the complaints that's made. Tom can tell you that very few, it's a very small percentage. The other method is, well, there's a number of different methods, and sanctuary is one of them, as you probably know. But the other method is UNHCR, and it's an informal method. And you can go to the UNHCR officials and say, look, my lawyer did a terrible job on my case. On appeal, the federal court went through this, and I was rejected. We went through the PRA process. The PRA process rejected us as well. But I can tell you we're in a very serious situation. And in that circumstance, what happens is the UNHCR will investigate your case. And if they feel that there's an injustice here, and if you were to go back, they will intervene. This is all done informally. They'll never tell you about this, but they'll intervene. And the minister, if they so decide and agree with UNHCR, will then prevent you from leaving the country. But that's another method. But the other one is people take refuge in churches. And we have examples of this taking place all across Canada where they'll be sheltered and they won't leave. So, and that creates a problem because obviously their mobility is restricted. They have to stay within the sanctuary. The authorities will not go into the church to remove the people. And an ongoing battle, sometimes through public pressure and advocacy, the minister intervenes and allows the family to stay. So there are a number of different kinds of mechanisms, both formal and informal, that allow individuals who are rejected from going back. But do we see governments drugging people, putting them on flights, returning them, and individuals are stuck abroad, and the other authorities in that country take them over and they're tortured, or worse things happen? Yes, there's far too many cases of those.
We perhaps should move on, but just a couple of comments. One is, you say you can go to the High Commission of Refugees, and if you've finished trying the processes here, you can go to one of the international human rights bodies and say they got it wrong. And then that body has a bigger voice than you do in speaking to the government and saying, we think you got it wrong and don't deport this person. They do sometimes, as I mentioned. Second point is, I mean, the prosecution issue, James, I mean, that's the way we deal with the people that have committed crimes, whether they're war crimes or whatever. And this country's been remiss at not wanting to do that. I mean, the Dutch have done a better job, I understand. And I understand why they don't want to. It's because it's hard. And if you don't, then the person's loose, which is what we said at the beginning. That's what happens in our criminal process. If you don't produce the evidence enough against the person, you say, you know, case dismissed, and the person's loose on the streets, and that's how it's always been. But at least you've had a go at using the normal tools of the law to deal with the situation.
Tom, I'm in total agreement with you. However, as you pointed out, the situation side with respect to using criminal law is problematic. And the reason it's problematic, there are a number of reasons for it. But one of the reasons is a tremendous cost. To prosecute someone for a war crime using universal jurisdiction because they're non-national and they committed this crime against humanity in another jurisdiction, you need witnesses, you need documentary evidence. So prosecuting someone in those circumstances, which I agree should be done, is not going to be inexpensive. It's going to be very expensive to do. And the outcome, because the standard of proof, keep in mind the standard of proof for criminality is beyond a reasonable doubt. It's a very high standard in terms of convicting someone. Even for serious international crimes, unless you've got individuals on tape and there's evidence, it takes a tremendous amount to convict someone for an international crime. So the process is long, it's expensive, and governments, look at this, and we've had many war criminals who have been prosecuted but never convicted. And so the experience of the Department of Justice in prosecuting these individuals has not been good. It's been extremely expensive. So that's one of the problems. The other problem is in terms of the undesirable, unreturnable, is that you can be excluded and the standard of proof for exclusion is lower. It's the civil standard. It's a balance of probabilities. So the evidence required for you to be excluded from refugee protection is not the same standard because you're not in a, obviously, criminal proceeding. You're in a proceeding to determine whether or not someone is a refugee or should be excluded from refugee protection for valid reasons, because obviously you do not want to give refugee status to someone who's created refugees. That undermines the integrity of the international refugee protection system. The system is intended to protect those people that are the most vulnerable that have suffered persecution or are likely to suffer persecution. Not those persons who obviously created the refugees in the first instance. So you're not going to do that, and you want a mechanism by which these people are taken out of the process. But by the same token, you cannot send anyone, irrespective of who you are. You could be the world's worst criminal, but your right to life, your right to security, et cetera, you will never be set back to persecution or to torture, despite the fact that that individual may have been responsible for torturing, killing, and persecuting thousands, if not millions. So, that is the problem, and the problem is what should states do? And I would say, agree totally with Tom. You should be prosecuted, and you do it in one of two ways. If there's an indictment internationally for the International Criminal Court, then that person should be sent to The Hague, and in The Hague, they should be prosecuted at the ICC. If there's no international indictment, if the person isn't at that level yet, they've committed very serious crimes, they should be prosecuted within Canada under universal jurisdiction. And yes, the question then becomes weighing the evidence on the part of the prosecution. Because if this process is going to be long, if it's going to be expensive, and if the outcome is in doubt, then you can't do it because it's not reasonable to do it. Yet on the other hand, that principle should apply, I think, because otherwise, what are we doing? Well, we're allowing impunity for very serious crimes that have taken place. And the international community, I think, has undertaken to end impunity from these kinds of crimes. And if we're not going to be prosecuted, I think we're really buying into this whole process where individuals who have committed very serious crimes are immune from being brought to justice. So I think the careful thing is that the governments or the prosecution in reviewing these files have to determine whether or not there's sufficient evidence. and the likelihood of prosecuting these people and getting a conviction is reasonable. And so what's the standard? I don't know what the standard is, but I'd say if there's a 50% probability of a conviction, then they should prosecute.
Just one last little thing, because I think people are getting tired. You know, as you speak, it reminds me of the Singh decision, because, and I don't have the words in front of me, but the government argument was that to hear, because if you remember in the Singh decision, you had an immigration appeal division, and it could decide whether it heard the cases. And the Supreme Court said, well, the process isn't fair, and it chopped out that decision making. So the Immigration Appeal Board had to hear all the cases. And the government argument was that it was going to cost too much and it was inconvenient, we had a backlog already. And the court essentially said, you should have thought of that when you signed the treaty and when you decided you wanted human rights. And because they come with a price. And so, James, I passed you the thought of the Singh decision.
Thank you, Tom, because I think that's probably the most.
Thank you for bringing things full circle there. I want to, in gratitude, give you what has become one of the really prized items at York University. It can only be achieved by giving a talk here at McLaughlin College. So you become part of the elect.
Oh,
Thank you very much.